Question we're often asked is, what are the applicable tax systems to a decedent's estate once they've passed away? We look at those tax systems in our estate planning phase to see if there are ways for us to save or to minimize exposure to those tax systems through the planning phase. Those tax systems have different limits that are updated each year. The three tax systems that we review are the estate tax, the inheritance tax, and income tax. For decedents dying after 2019, the DC estate tax has been changed, allow individuals to pass on $4 million estate tax free. Maryland allows a $5 million estate tax exemption, and Virginia currently does not have a state estate tax system. In addition to the local jurisdictions' tax systems, there's also the federal estate tax, which is applicable to everyone in the United States or anyone who holds property in the United States. Currently, the federal estate tax exemption allows individuals to pass on $11.7 million estate tax free. But as we've cautioned clients, and we will continue to do throughout the year, that estate tax exemption amount is slated to expire if there's no congressional action prior to December 31st, 2025. Certainly, we've seen a lot of discussion both within the estate planning community and without that have discussed that those limits might be lowered further sooner than 2025. It may be prudent to review your assets and to see where the estate tax might be applicable and if there are any opportunities during this period for taxes to be limited or exposure to taxes to be limited. In addition to the estate tax, we often review the inheritance tax systems as well. Maryland is the only local jurisdiction that has a state inheritance tax system. There is no federal inheritance tax system. Maryland indicates that there will be a 10 or 11% tax on assets that are passed to individuals who are not exempt. Luckily, children, grandchildren, and other linear descendants are exempt from the inheritance tax. However, nieces, nephews, and friends are not. It's important when preparing an estate plan to consider whether inheritance tax will be paid, and if so, to provide enough liquidity throughout the plan to ensure that there's adequate assets to cover that tax. The final tax system that we review is the income tax system. Generally, the big takeaways for clients are that all assets as of the date of death are evaluated for tax basis. The date of death value, or the market value on the date of death, becomes the cost basis for which beneficiaries inherit assets. That cost basis carries with the property and will become the new cost basis for the property when it is sold. Oftentimes, because assets are appreciating, those cost bases are higher than the decedent's cost basis prior to death. Because of that, we often say or discuss what's called a step up in basis. That step up in basis will allow for a more favorable tax result in the future for the beneficiary. Just as the cost basis can be increased because of an appreciation of assets, it can also be decreased or have a step down in basis if the value of the asset on the date of death is lower than the initial cost basis purchased by the decedent prior to death. It's important that we review these basis issues where they are applicable in an estate and discuss how to maximize the use of that current system. Like the estate tax, there's been a lot of discussion about the elimination of that ability to have a basis adjustment or to have that step up or step down in basis. This is something that should or can be reviewed during the estate planning process.